What I thought I would do with you today is take you a little bit through how we got to our conclusions. Our conclusions themselves are online and available, as is all the research material that went into them, and I'd be delighted to take questions about any of that from you now or afterwards. Janet and Jana have my contact information. But I thought what I would do is take you through a bit of our reasoning, a bit of the research that we did that sort of informed the conclusions that we ultimately reached. I thought at this point in your work that might be a helpful exercise. So why did we get into it? This quote from the Governor General really captured for us what we were up to. I should say the slides are the same on both sides, and when Jana first showed me the setup here today, it occurred to me this is a little like the Inns of Court. For those who've been to London, I quite like this arrangement. We have it in Toronto. If ever you have the chance to see Osgoode Hall, the Law Society's office is there. And we want to know what the challenges we have in Canada in tackling the future. The regulator of the legal profession in Ontario is still referred to as the Law Society of Upper Canada, a term that otherwise disappeared in all of our books in 1867, but the lawyers have hung on and made sure that change did not happen. But our Governor General, you might have had a Governor General if he hadn't fought the Redcoats. This is one of the things that we maintain. He is a lawyer by training. He taught at my alma mater. He's now our Governor General, which is the Queen's representative, but also our head of state. So our Prime Minister's head of government, the Governor General's head of state. And his quote on the screen there really captured, I think, nicely what we set out to accomplish with our work, which was part of a speech he gave at one of our conferences, and reflected one of the two starting points that we had in this work. I mentioned the Canadian lens. That was one of them. We realized that most of the writing out there was about someplace other than Canada. And we were interested in how does that relate to what we're doing. The second starting point we had was that Canadians rightly expect and deserve a vibrant and relevant legal profession. That we need to be part of their lives, and we need to be part of their lives in the places where their lives are unfolding today. And that's not necessarily the way things are unfolding right now. And that it would take some of the innovative thinking that the Governor General references to get there. His reference to the social contract was also one that really stuck with me, and we'll talk about this a little as we get going, but if we're not playing our role in society, are we living up to our bargain with the social contract? We are a self-regulated profession in Canada. We took on that role on the basis that we would do certain things that are important in a democracy, in a market economy, in the kind of civil society that we expect to live in. That's all well and good, but when we see studies as we have in Canada that suggest that only 1 in 7 legal problems are today being addressed with the help of a lawyer, I wonder if we're living up to our end of the bargain. If you had a contract where your co-contracting party was doing 1/7 of what it said it was going to do, might you go and see your lawyer? Now, I think that's a little what led to the kind of change we saw in the UK and the kind of change we saw in Australia, where the politicians finally realized that things were so serious that there was a political advantage to getting involved in this. And we can discuss as we go, how that turned out. And I don't necessarily want to suggest that the politicians should not be part of that discussion, but I think it does behoove us to be thinking about it and getting out ahead of it and perhaps proposing some of the solutions that could lead to the kind of change that we think will be helpful and reinforce that role that we play in society. In our discussion last night, Julie was asking, well, how do we do this sort of more mechanically? So let me take a moment here to say, I think we structured things a little like you have. We too had 3 teams looking at innovation, regulation, and education. We had a steering committee that's sort of tried to identify those places where things might butt heads, as you discussed this morning, and try to make sure that at the end of the day we all went in the right direction. Something we did that I found particularly helpful in dealing with lawyers, though, was to go and get some evidence. And so we commissioned some research as to what was going on in the marketplace. We wanted to look at what was going on in the profession, sort of the demographics, where are people practicing, what kinds of practices are growing, where's the innovation happening today. We looked at some case studies of people who have innovated to try to understand, well, what was it that got them going and how successful has it been and what obstacles might they have encountered, and be able to pinpoint these things the way a business school case study might try to bring these things to the fore. We also tried to understand what was going on in the minds of the clients. And I found that to be a particularly helpful piece of research because it's a little hard to argue with that your client really wants this right now. There are some things that clients may not spend their days worrying about the way we do, codes of conduct, rules about conflicts and whatnot. That's fine. But the other pieces that they brought to the conversation I found were particularly helpful and really placed clients, therefore, at the center of what we were doing. In terms of reaching the community and the discussions about how we interact with people not involved in this was something we had to turn our minds to as well. But I think it's very important to get out and meet lawyers and talk to lawyers about this. Most lawyers, of course, are not involved at this level. I don't know how many lawyers there are in Michigan, but they're not all in this room today. You are the committed, you are the ones who are find some satisfaction or feel some obligation that brings you to participate in the life of the bar in this way. Many of our colleagues spend, their time doing other volunteer activities and practicing their jobs and don't therefore spend the time thinking about these issues the way we do. And I think it's important to get out and have a conversation with them. We tried to engage online and had some success with that, but our greatest success was really when we were able to get out and sit down with people and ask them the questions and engage with them on the issues that we were reflecting on. So I'd certainly recommend that approach as you engage in this. So that's a little bit how we did it, and I'd be delighted to speak to the co-chairs or any of the committees as it unfolds about how we did our work there as well. But let me take you now into a bit, as I said, some of that thinking, that reflection that went into our recommendations, and it started really by asking, what does change look like? We realized that lawyers were not playing the role they might have in the past, that clients seemed to be asking for new and different things. So we started to ask ourselves, well, where are those clients now finding something that's interesting? And this article in the ABA Journal we thought was a particularly interesting starting point. I think it's still online. It now dates from October of 13. But what jumped off the page at me was in that article they discuss no less than 7 firms who employ between 500 and 999 employees using technology to deliver services over the web or using software to do e-discovery and whatnot that are completely outside of any of the law firms that are practicing today. 999 employees, they're making payroll every month, they're paying the rent, and they've been around for a while. These aren't, your normal techies, a couple of folks in a garage somewhere with a hacked up computer. These are viable businesses that are starting to really do the kinds of things that lawyers have traditionally done. And they're making a go of it. You go down one step in how they stratified this, and in the level of 100 to 499 employees, there are actually 21, back in October 13, already 21 businesses doing this kind of work, and doing it in ways that connect with clients, deliver something perhaps of greater quality, certainly more quickly, and are scattered across your country. Now, we didn't have data on Canada on this, but we're starting to see a similar phenomenon emerge in Canada as well. Related to this, I'm delighted to say I was in your country, sitting on the beach in Florida one spring break when I had the time to enjoy a Sunday New York Times, which with 2 small children doesn't happen very often. And in that particular edition, they had an article on what was new in Silicon Valley. And that led us to a firm called Weavorse. I don't know if anybody here has heard of Weavorse. This article was about what was new in Silicon Valley, not what was new in law in Silicon Valley. And they had a whole host of folks, including Weavorse. Well, Weavorse is a service that helps you if you're looking to get divorced, relatively amicably most of the time, I understand, and founded by a woman who was practicing family law in Idaho, if memory serves, and got frustrated with the traditional way of delivering legal services, but couldn't find anybody nearby who was willing to tackle this and come into some sort of a structure that would let them do things differently. So ultimately, she up and left to join Silicon Valley because that's where she found like-minded people. And now offers her service in a number of the states. It's growing. I don't know if Renee, you're nodding, you've heard of her. I don't know if you know how many she's now authorized to do it in, but a number of the states. And the service is offered online. You go to her website and start answering a number of plain language questions. From there, the computer takes your answers and runs them through one of 19 algorithms. And of course, you'll all remember your algorithm class from the law faculty days, right? Algorithms. To figure out what is the most likely way your divorce will end, and then funnels you through a process that gets you there as expeditiously as possible. We had her speak at one of our conferences, and she was a great speaker. If you have the chance to have her in, I recommend it. And at the end of it, one of our puzzled attendees said, well, how are you doing all this as a law firm? And she just shrugged and said, I'm not a law firm, I'm a tech company. And that's the mentality that we're seeing starting to emerge for those who are starting to shake it up, those who are the subjects of this article in the ABA Journal. We were discussing last night some of the students at the University of Toronto who have access to IBM's Watson. And if you Google Ross in capitals, R-O-S-S, and Watson, you'll find the work they're doing to use artificial intelligence to run through reams of cases and commentary and statutes to come up with the answer to the question. And what I liked about them and some of the others who have come at this is they say, we're not here to replace lawyers. And I agree with that, because there's something about what we do that is very human. And that means it's going to be very unpredictable. And if the issues around justice and law were easy to sort out, jurists and philosophers would have dealt with them all centuries ago. There's something we still add that's very hard to grab hold of sometimes and takes that training that we have. But there are tools like artificial intelligence that can get rid of the rest and can expedite the process, perhaps give us a better quality answer for some of those steps along the way. And then the lawyer comes in at the end to really solve the really difficult part of the problem where the real value is added. This work they're doing with Watson, when Watson comes back with its answer, I keep wanting to say his answer, but it's actually its answer. It'll say, well, here's the answer that I think it is, and here's my confidence in that answer. And on a scale of 1 to 100, it says, I'm 87% confident this is the right answer. And I asked them, have you ever gotten to 100%? Has the machine ever come back absolutely certain this was the right answer? And they said no. They've got it into the 90s now, but they haven't got it to 100. And I think that's helps me sort of frame where I see us in the future, that there is always going to be something we do that's very important and different, but we need to find ways to embrace technology to help get there more expeditiously. Here's another example of what law, or what change rather, looks like for us. This is a picture I took on my way to work one morning. This was an ad campaign run by Raymond Chabot, a mid-sized accounting firm in my town of Montreal, that serves obviously business but also individuals, given their market and this kind of marketing that they're doing. In this case, it was their bankruptcy service that was advertising. I work for an airline in my day job, so anytime you see airline folks hanging out with bankruptcy folks, it tends to send ripples around and to reassure everybody that no, there was nothing on the go. But they ran these ads probably about 2010, 2011, so shortly after the economic crisis here, when our federal government started warning Canadians to say, we are seeing in the economy a number of the things we saw in the American economy before it fell over that cliff in 2008, and maybe we should start to change course. We didn't quite suffer this economically as you did in 08 and 09, but there was great concern we would. And this accounting firm shows up with these ads in the middle of it. And for those of you whose high school French was a little ways back in your education, the little sign that woman is holding says, I have debts, but I have rights. I was outraged by this. It ruined my day. I hadn't had coffee yet, and it ruined my day. Anybody else have that reaction? No. I bet one other person showing this slide had the reaction. I've heard the joke that your kid's going to go to law school if they read the rules to Monopoly. I remember struggling with mortgaging my hotel when I was 8 years old and reading the rules of Monopoly. I guess you become a bar president, I suppose, if you get outraged by the advertising that accountants put out there. But your rights. Why would you phone an accountant about your rights? That's been our bread and butter for centuries. Yet there they are saying, come and talk to us. We'll renegotiate your car loan and your mortgage and your credit card and whatever else. Well, renegotiate, that's something we all do every day. And last time I checked, all those different documents they're talking about were contracts, which we ought to know a fair bit more about than they do. But there they were, seizing an opportunity in the marketplace, coming at something very different. They didn't say, well, we're a bunch of banking lawyers and we're very good at it. They're on the back of the bus saying, here's a problem that exists in our communities and we're offering a solution to it. Now, the accounting profession, of course, represents a number of challenges for us because we know that they've employed a large number of lawyers now. We saw one study that suggests as many as 5,800 lawyers now work for the big four accounting firms around the world. They are coming into this field in a very big way and bringing with it the expertise they have about delivering professional services, and they've been very effective at changing their business model. Back in Toronto, there was a young lawyer who left one of our larger firms because she got frustrated with the document review process that goes into a lot of those large transactions and set up an automated system to do it. She recently sold it to Deloitte, who now offers that service in the legal market in Toronto. We've seen some other change. So I've started with sort of those techies scattered all over the place and trying to come a little closer into what might be familiar, but we've started to see change in some firms as well, and change that is likely going to take hold and start to change expectations in the marketplace again. So here in the United States, we often point to the likes of Littler Mendelsohn with their CaseSmart system that's been showcased at a number of tech shows where clients like I can go on me, I, the English major, me. I'll blame my French on that. How's that? Go online and instantaneously see the status of all of my files, updated every 24 hours. Where are they in their process? How much work has been done on them? Are they on track? Are they falling off track? And Safeguard Shaw with their process mapping exercises that are something that comes to us from the manufacturing sector, but is starting to show that maybe we can learn from others and can change expectation, or can change the way we work to better meet client expectations. And I'll come back to process and process mapping in a few minutes. So we looked at that change, we looked at how it related in Canada, we commissioned 7 separate pieces of research. All of them, again, are available on our website for you. We asked Richard Susskind to update some of his work. Bruce Mcluhan, who writes under Adam Smith Esquire, updated some of his work for us. You'll see some stuff about the Canadian legal profession and with some of the innovators. But if you only have time to read one piece that's up there, I wouldn't even recommend this report. I would recommend the report from the public opinion research firm we hired who spoke to clients. It's not very long. It's about 16, 18 pages worth of summary of what we heard from them. But that was, for me, really the critical piece of the puzzle for us. What we heard back from the clients when we spoke to them. So let me take you through a bit of that. We certainly heard about the effects of globalization. We heard about the desire to do more for less. And we started to hear from them snippets that, in fact, change was not coming from within the legal profession. We started to hear from them talking about where else they were getting legal advice. My Law Society in Quebec recently released a study, and they asked people, who do you turn to for legal advice? And it was one of those, when the surveys come around, sometimes you have to only pick one, but this is one you can check sort of all the boxes that apply, kind of an exercise. So the numbers don't round to 100. But the single largest source of legal advice in the province of Quebec right now, our second most populous province, any guesses? Close, they made the list. Friends and family. 48% of Quebecers turn to friends and family. Now, we're a pretty large bar, but we're not quite that large. 48% turn to friends and family. If you add in business contacts and online sources, you get to 76%. Lawyers rank at 37%. So we've got a little ways to go here, and it's because people are starting to look for answers the same way they're looking for everything else, back to ideas about globalization and using technology. I'm troubled by that because, on the one hand, if I were running a firm, and I'm in-house counsel, so I'm not, but if I were running a firm, that's a lot of the low-hanging fruit you hear the business people speak about. There are a lot of people out there whose legal problems are going completely unaddressed by a lawyer. You don't even need to pry that client away from somebody else. They should be easy pickings in some ways. But why are we connecting with them? Wearing again my hat as a bar president, I don't think in 2015 it's right that people can't get access to a lawyer in the legal system. I think if we're going to hold ourselves up to be of the kinds of a system that reflects the kinds of values that we think are important, it's not right that people are left with a choice of either living with a problem or taking that problem into their own hands. That we need to be present and engaged with them in places and in ways that really connect with them, and that comes from what's going on around them. We certainly heard about the need for greater access to justice. I'll mention as well, we just had a nice chat at the table, Linda and I, about how we structured our work. We deliberately also set the access question aside from our futures work. We had a parallel project underway. We deliberately did not spend a lot of time trying to define the two mandates. There was a lot of pressure on me at the outset to try to draw a nice clear line between these two pieces of work. And I said, you know what? It's a room full of lawyers. It's going to take us 10 years to solve that answer, and we don't have the time. So let's just get at it. And where we have opportunities to work together, let's make sure we take full advantage of them. Let's make sure we have a good flow of information between the two groups so we know what everybody's up to, a little like what Andrew was showing you earlier. We keep tabs on what the thinking was. Let's leverage what each other brings to the table, but let's just get at the project. And the real driving force behind the decision to keep them separate was that access involves a number of other stakeholders as well. Whereas the profession work that we did was really about the profession, and this was something we were doing ourselves. Now, we're one of those stakeholders on the access front, and there's much I think we can take from the futures work and help address problems of access. But access or not, the profession needs to update itself. That really wasn't our motivating force behind the futures work. It was sort of one of a number of things that we were looking at. But we certainly needed to find better ways to deliver the service, whether it was in the traditional sense of dealing with access to justice or as we conceived of it more broadly. And the work of the Access Committee is up on the website as well, and I certainly commend that to you as well. I think they came up with some very helpful things and touch on a number of things I saw again in the report that came out of your November meeting about unbundling, for example, and the like. This quote from Matt Peters is one of my favorites from all the consultation that we did, in part because it usually sort of paints very starkly just how far we have to go by the time you get to the last line in the reference to the Industrial Revolution. I thought it was also very helpful, though, as I sat back and thought about it a little more, that the Industrial Revolution, of course, is when management as an art and a science really came into its own. And that really is the key to a lot of what we're talking about, is how do we manage our businesses differently to better deliver the service, to better connect with the people that we are trying to serve. And what came through loud and clear, as I will take you through in a second here, much of what is being expected of us now comes from those kinds of management processes, that kind of managerial thinking that's very common in the Western world now, that's influenced how people look at the problem. So let me say there were three things that jumped off the page in the client research that reflect that. The first was clients absolutely wanted predictable pricing. They wanted to pay less for legal services. That's no surprise, and I don't want to minimize that. However, you didn't need the Bar Association to conduct a 2-year project to decide that clients wanted to pay less for legal services. They certainly do. But they also recognized value. And that came through loud and clear and got them into talking about predictable pricing. Predictable pricing, of course, is having a budget. And being in-house counsel, I get a little bit of a sick pleasure speaking to rooms full of private practice lawyers saying budget. Budget, budget, budget. Because everybody's shoulders tense and you see the jaws clench up. So let me give you a little insight into how I came to realize just why a budget is important. I think it reflects what we were hearing from the clients. And when I do this with groups, I tell them the story of my friend Klaus. Klaus is the Chief Operating Officer at Air Canada. We are the largest air carrier in Canada, but not nearly the size of the major carriers here in the States. But Klaus is responsible for 600 flights a day, including that flight that brought me from Montreal yesterday, which meant Klaus is ultimately responsible for having pilots who are trained on the aircraft type, who are properly rested, who are delivered to the airport on time, who are properly briefed before they get through, have their secure clearance. He has to make sure that the flight attendants, same drill, qualified, rested, delivered, briefed, security cleared, had to make sure there were people getting the bags into the chute and properly tagged to get to where they were supposed to go, people at the gate to make sure the right people were getting on the right plane, people to make sure that all those thousands of serial numbered parts on a plane are properly documented so that we know it's airworthy, people who had to make sure we respect our financing covenants with where those planes are going, that we respect the bilateral treaties between Canada and other places. 85% of our flights leave Canadian airspace, if you can imagine. Principally because we're nipping over someplace like Michigan to get somewhere more quickly. Is to make sure that we have the proper clearances on the ground, proper clearances in the air, that the dispatch knows how much fuel to get into the plane, that, we get most of the bags into the hold. We do our best for that. So, something to eat when you're up in the air. All of these things have to happen for the one flight. And they're going to have to happen 600 times today. And they're going to happen 600 times, 365 days a year, whether there's another volcano in Iceland interrupting traffic across the Atlantic, whether the likes of our 2 security forces decide there are new rules at the airport for screening passengers, or whether oil shoots back up to $140 a barrel again. And Klaus has to do it on a budget. So imagine the look on Klaus's face when I walk into his office and say, well, we're all set to go, Klaus. It's a trial set for 2 weeks in the Montreal courthouse. We've found what we think are the best counsel to represent us on this one, but budget? Well, Klaus, who knows what could happen in a courthouse, Klaus? We look ridiculous. Right? This is a guy who deals with a level and a degree of complexity and risk that's far beyond anything that we're actually going to deal with. Now, what we deal with is human. I said that earlier. And so, of course, your adversary is a little unknown, or maybe is known, and you know how difficult they can be, and you never quite know how the witness is going to behave. But really, the range of things that could happen in a typical North American courthouse compared to the range of things that could happen to an airline on any given day, I suggest is an awful lot smaller for us than it is for them. And we create a space between us and them every time we insist you can't do things on a budget, for example. Now, related to this, what we heard as we probed the budget point with clients was we found there were individuals, principally, more than corporations, this was more from the individuals we spoke with, who would actually pay your full hourly rates. They don't even want a discount. if they only knew where the bill was going to stop. They don't call the lawyer because they just don't know what it's going to cost at the end of the day. Now, where I see hope and opportunity for us in this is, of course, nobody's obliging us to use the billable hour. Our managing partners are, I suppose, but it's not in the Bar Act anywhere in Canada. It's not something that's imposed on us by the laws of physics. It's something we could change that would make a very substantial difference in how we deliver the service. To do that in a way, though, that means your firms remain sustainable takes some business knowledge. We need to start looking at the kind of data that is in the firm and understanding what goes into a particular file. Instead of using our lawyer instincts to find what's different, use our lawyer instincts or our business instincts to find what's similar. And how can we start to package things in ways that we could put a predictable price on them? Now, related to predictable pricing, the clients also spoke to us about the need for process. Of course, what I just described about how you might develop budget goes back to process. You need to understand all the steps that go into doing a particular file. And so these were very closely related, but it was one word that really jumped off the page at me because we did not just speak to engineers and MBA grads, but across the board, people spoke about the need to see a process. And what came to light for me there was it's what those of you in the room may know as the Mcluhan effect. For the younger ones in the room, it's the Facebook effect. It's that the medium is the message. And today, everybody is quite accustomed, as Bruce proved yesterday, violating the rules of the Art Institute, in using things like Twitter. Using Twitter, using Facebook. And they want to share with you their latest, greatest thought on how to solve their case the moment it occurs to them. Well, that's very disruptive when you're trying to concentrate on developing an argument for an appellate court, for example, or that really difficult piece of the transaction that you're grappling with. But we can't just say to them, oh, I'm sorry, you're just going to have to hold all your tweets. You're going to have to find a pause button there and not interrupt me. We're going to have to find ways to include them in the process. They expect us to use process, and they want to be part of that process, because what's happened with these kinds of tools is made everything else very accessible. And the longer we continue to italicize Latin and use footnotes and whatnot, the harder that's going to be. We will have to do that when we show up in front of judges, but we're going to have to find other ways to do this when dealing with our clients, and probably ways that do it online. You think of the remarkable number of things you can now purchase online, or kinds of interactions you can have online. People expect that from the legal system. Related to that is transparency. They want to actually not only know that you're using a process, but they want to see the process through. Anybody ordered Domino's pizza off their phone lately? No? A few? Have you watched it as it gets made?
No, my wife does it.
Your wife does it? Okay. My kids get a kick out of this, that you can see the pizza's on the counter, now it's got all the toppings, and now it's in the oven, and now it's in the car, and now it's at your door. And I can watch this all unfold on my phone after I place the order online. I think clients will understand the difference between building a pizza and building an appellate brief. But they do expect that you're able to articulate where things are in the process, express it in a way that they understand so that they can be part of the process. And this point really came home to me in the midst of a long case we were arguing in Ottawa. The small team of us had gone up from headquarters for this, and in the midst of it, the other side presented what we thought was a rather interesting settlement proposal, as can happen in any particular hearing. Interesting enough that we convened a call with a number of vice presidents at the end of the day to present it to them, and they agreed it was interesting, but they thought our president needed to weigh in on this, given the stakes of what was involved. And I said, well, okay, that's fine. I'll reach out to his assistant. I'll set up some time with him tomorrow to brief him and share our recommendation, and we'll let you know how it goes. And I was about to hang up when somebody shouted down the line and said, wait, who's going to make the PowerPoint? PowerPoint. This is a settlement discussion. Who's going to use a PowerPoint for this? Now, it gets all the more perplexing if you knew who our president was. Still is. Kaylin Rovanescu is a lawyer by training. Spent 20 years doing M&A work in downtown Toronto in one of our large firms. He's a very easy president for me to brief because I can speak to him like I speak to a lawyer. Back to that italicized Latin, it comes out of my mouth italicized, right? We can mentally have footnotes in our conversation as it unfolds. But what I learned from that as I probed it with the team afterwards was, of course, if that's how I had briefed Kaylin and I were going to have a really great conversation. Kaylin and I were going to have a really great conversation. And in this day and age, that doesn't cut it. Because all those other people whose lives were going to be affected needed to be part of that conversation. And if you can do something as simple as putting it up on a screen like that with bullet points, all of a sudden they feel empowered enough to be part of that conversation that matters to them. And these are some of the small things we can do to actually connect with them and show the relevance and the value of what we're contributing to the discussion. Now, all of those examples, of course, A, are airline examples, and B, involve rather senior executives at a rather large corporation. But something we also saw in this research was those aren't the only people who are speaking about this. And what I learned from that was, though Klaus and Kaylin are my clients, there are 27,000 other people who report to Klaus and Kaylin. And in every other corporation, you have that same kind of hierarchy going on. And so all of your individual clients, with their personal problems, not their work-related legal problems, are accustomed to thinking in this way. These are the influences on their lives that are shaping their expectations. And that's why they too are talking about things like budgets and want to see the process and want to jump into the discussion when it suits them. They want to see how things are unfolding. That these things are trickling down. So though those examples came from the corporate world, I hope you'll see that they can have a broader application. And I think are important guideposts as we find our way through to delivering legal services differently. The last point about this was the difference between how we see value and how the clients see value. And this is a conversation I think we're going to have a lot more often, because I remain convinced that what lawyers do is very important. Nick Robinson from the Harvard Center on the Legal Profession wrote a paper on alternative business structures where he referred to it as being a very law-thick world. And I think he's absolutely right about that. There's an awful lot of regulation out there. Our clients continue to find new and creative ways to complicate their lives. And though what we do is very important, I've now come to the view that I think there's very little that's sacred about how we do it. Once we've secured those important values and principles that are the foundation of the solicitor-client relationship, the rest of what we do, I think, really needs our reflection, and hence why I was so excited to come and join you today. The concept of waste, of course, is the opposite of value. I think David and Karen, who are two lawyers who also practiced corporate commercial law both in Montreal and in London, are bringing to the discussion now and helping lawyers identify where it is in what they do that maybe we don't need to do so much more of. And I think if we found our way to being able to demonstrate in ways that resonate with people what it is we bring to the table, they'd be much more willing to pay for it because they appreciate the value. That came through from our conversations with the clients as well. So we took all of that, and that's a short summary of I'm sure it seems long after you've just had lunch and not had a chance to grab coffee yet, which I, of course, welcome anybody to do while you're here. That led to our report, which is also available online, and I think copies have been sent around. 22 recommendations covering innovation, regulation, education, as I mentioned. And I hope when you work your way through it, if you have the time, that you'll see our optimism about this, that we share William Hubbard's view, that there's an awful lot of opportunity here for us. We see opportunity in innovation, but call for ways to encourage more innovation by freeing us from the traditional structure of the firm. Must it always be a partnership of some sort? Is there some way that we can use other vehicles to better connect with those who we're trying to serve? Is there a way to use that to help bring in other practices into the fold? Something we heard from clients when they spoke about wanting their problem solved and not just their legal problem solved. The recommendations in this section of our report really build off those case studies that we spoke about earlier on, and led us to realize that the skill set that lawyers are going to need in the future is not one that's being taught in law schools today. I'll come back to this in a second on the education point, but generally you can either learn the skill or buy the skill. And when we looked at both routes in our work, and as you talk about the buying the skill, that's what really took us to a new approach to regulation, which we think is a responsible form of liberalization of the regulation, one that would take those rules that govern us today and apply them to everybody who's in the business delivering legal services, so that those rules about the rules and the codes of conduct are actually protected, even though there are non-lawyers who may be owners in the business, whole or part owners of the business, but in a way that we can then draw on their expertise. Because when we met with folks who were interested in joining legal businesses, met with people who would be willing to bring some of their expertise to the operation, they often said, well, we'd also like to enjoy the upside. I mean, if we're going to put in all this effort, we'd like to see the other end of this. And so we could come and consult to you for a couple of weeks, but we'd really like to get in there, get our hands dirty, and contribute to the process. So we need to put some safeguards there, but we think we can mitigate that risk through those safeguards, the risk rather, we have non-lawyers who will be involved in the delivery, mitigate that risk and draw on their expertise in helping us find better ways to connect. The Swiss Chalet example is a little like some of the other ones we've spoken about in terms of flying the plane. I mentioned a moment ago multidisciplinary services. We certainly heard, or firms rather, we certainly heard from a number of people that there was a great interest in doing that, making that available in the Canadian marketplace. The regulatory changes, I touched on them quite quickly. The idea that we would move to an entity-based form of regulation so that everybody's subject to the rules. There are still some details to be worked out around how one would open the ownership up to non-lawyers. The debate is moving forward quite quickly right now in Ontario, as well as on our prairie provinces, and we're certainly going to continue to participate in that. But we're hopeful that a few things may come if we could bring this expertise in. Diversity, which is one of the points I know that you'll be looking at as well, is something that we grapple with, and we think if we could employ more closely people who've had experience managing services firms elsewhere in the economy, we might do a better job on that front. And as you embark on the reflection about whether Michigan should adopt an ABS kind of model or not, let me leave you with a couple of thoughts that struck us as we worked our way through this. I think first of all, when we think about the benefits that could come from ABS, let's not compare them to some idealized view of the lawyer-client relationship. Let's compare them to where we are today. Because today's system is a good system that's served us well for an awfully long time, but it's not without its faults. In every jurisdiction in North America, there are disciplinary hearings happening on a regular basis, unfortunately. There are gaps in the regulation. There are things that we could be doing better. So let's ask ourselves if we could actually be moving things forward as opposed to reaching some idealized state if we went down this particular path. Some people have said, well, really bringing in outside investment is only going to reduce the cost of delivery of service by a marginal amount. Nobody's really going to benefit from that in terms of access, so why would we take the risks involved? I actually think we might find that there's an awful lot more than a marginal decrease in the cost of delivery if we could find more efficient ways to do the service. Janet and I were discussing on the way up this morning a group that set up shop, not an ABS, but a group that set up shop in Walmart in the Toronto region. It's not branded as Walmart, it's a little like McDonald's and Starbucks who rent space in a Walmart. And they'll deliver your will for $99. Overseen by a lawyer, heavily worked over by a paralegal, a lot of it delivered online. That's more than a marginal price decrease compared to what I paid for our wills when we had them done. And they're going to look at somebody who has a rather complex set of holdings all over the planet and say, no, thank you very much, but here's a referral, and go and see somebody who is going to charge more, but is also equipped to deal with those cases. They target a very specific piece of the market that I'm optimistic could help with middle class kind of access questions. That's the kind of change that and by the way, they're both MBA grads, the two lawyers who started this, so bring that management kind of thinking to bear to the process. I think that's the kind of change that could be very helpful and overlap with the access point and help reinforce our relevance by showing that we can deliver the service in different places, in different ways, and on a budget. Lastly, there's been, I'll just leave it this one, the possibility that somebody could own a law firm and other businesses, and that the nature of those businesses create a conflict is another issue that's emerged in the discussions around ABS. Nick Robinson's paper goes into this in a fair bit of detail as well. I think there may be something to that. I think it's something that we need to be aware of. But certainly in our country we have a long history of regulating industries and often prohibiting certain kinds of businesses from owning other kinds of businesses, and maybe that's a kind of approach we need to do here. At one point, our banks were not allowed to own trust companies and insurance companies and brokerages precisely so you would not have the too big to fail problem. Maybe we take a similar kind of approach if we see that there's going to be a tension or a conflict between the kinds of businesses that somebody who's investing in an ABS is involved in. So I'll leave you with those thoughts. I can't resist one more. The other one is, often you hear out of Australia, the money went to the personal injury practices. That's where the ABS investors ran first because it's the most profitable. It's true, they may be very profitable businesses, and I think it's true as a matter of economics, the money will go where things are most profitable. But I think once we get the innovators involved, what's most profitable could really change quickly. And so maybe in a few years' time, it's not the personal injury bar that is the most profitable. Maybe there are other things that come online as being profitable, again, serving new markets or serving them in a more cost-effective way. So those were some of our reflections on the ABS question in particular. I know it's a thorny one. I know it's one that is on the agenda. I'm not sure you could have a discussion about the future of practice in North America without discussing it. Happy to talk to you about some more of those thoughts. Although you will not find me suggesting that it's panacea. I mean, this is one piece of the pie. And it's one thing that we thought would be helpful if properly regulated as we try to find new ways to deliver the service, but it's by no means a complete solution. And I also think it's only one step. So as I mentioned, we had 22 recommendations. That's one of them. We have 21 others we still need to make progress on if we're going to get this job done, and we can't lose sight of those. Let me say just a couple of quick words here about education, because I know that's on your list as well. We expect to see the emergence of a number of related professions coming online. A little like you used to walk into the hospital, there were doctors and nurses. Now you walk in and there are, it seems, hundreds of different designations there to help you. Something similar happening here, and Patrick Ellis, who joined us yesterday, is one of them. Project management, data analysts, knowledge managers, a number of different related disciplines where people have some knowledge of the law, but their real expertise lies in another field. And those kind of designations coming into the profession to help us find these other ways of practice. Now similarly, we say lawyers need to know something about what they do. So we think about it as a T for lawyers, because we heard loud and clear from the clients and from those who hire young lawyers that the quality of legal training has to remain as it is today. That by and large we do a good job of that, but that is non-negotiable. And so we conceive of it as a giant letter T. On the vertical part of the T is that very deep training and deep knowledge of the law and legal reasoning. And that is really fundamental to who we are. It goes, like those values and principles, to the core of the brand, if you will, if you want to speak of it as a marketing type. That's what makes us different from everybody else out there, and is something that we need to continue to do. But we need to supplement that across the top of the T with a narrower band of learning that covers a much broader scope, so that we can more meaningfully engage with the other professionals we're going to be called upon to work with. So we're not suggesting go into a course in project management because we want lawyers to be project managers. But go into a course in project management so you can work in a more intimate way with the project manager in your particular operation. Understand the potential that lies there for delivering services differently. Similarly, we say don't expect the law faculties to teach that. If we need that deep training in the law and legal reasoning, don't say to your criminal law professor, hey, you need to learn about data management now. That's not their passion. If it was their passion, they'd be over in computer science somewhere. And we need people who are passionate about all those different areas of law that are the research and the teaching that they do. What we need to do, therefore, is bolt on to the law schools this other training, and that could be done by the bar, it could be done by other faculties around the campus, it could be done by a whole host of different folks. I believe the idea of articling is something that's getting some attention here as well. I know in Louisiana they're rolling out a pilot project on it. It's something that's part of our tradition. For those of you who are unfamiliar with it, once we're done law school, we both have to write exams to pass the bar, but we also have to spend anywhere from about 6 to 12 months in a law firm in what amounts to an internship of sorts. It's been with us for an awfully long time in Canada and is a helpful transition, I think, from school to practice. You have a supervisor who's going to have to sign off to the Law Society that, in fact, you did all the required steps. It's been increasingly hard for young lawyers to find articling spots, however, principally in Ontario. And that's led to the emergence of a new program, which I would recommend you take a look at, called the Law Practice Program at Ryerson University in Toronto. This is a program where, as opposed to just sort of watching the senior lawyer go about their day, you're going to actually go back to school for another year, but in a very methodical way get exposed to all those things that we think you need to be exposed to. Dealing with a difficult client, dealing with a difficult adversary. How do you actually present yourself in court? How do you go about negotiating and documenting your deal that you're working on? They'll go down to the courthouse, they're going to spend some time in different businesses, but a lot of this is being done online with avatars. So a very low-cost way to deliver the service, and with people actually engaged in teaching how do you do these things. At the moment, these are students who did not find articling positions. In the future, I wonder if these become the students who are really sought after because of this more methodical approach to teaching. So as you turn your minds to articling and post-call training, I commend to you the project that they have underway at Ryerson. Two quick last points that we touched on that are also noticed in your report of November, and I think fit within the mandate. Of course, diversity remains an enormous challenge for our profession. I think it goes not only to our credibility as a profession in terms, again, of connecting with the people we serve, but it's also an incredible wasted opportunity, it seems to me, that we're not being able to make good use of the talent that we have available to us. I'm optimistic that if we can break a bit of that cookie-cutter approach to being a partner in a law firm, that perhaps we'll find new career paths for lawyers, and that will be something that will help us increase the level of diversity within the profession and increase its inclusiveness. And that too is a lesson that comes from the business world. Nobody looked at me when I showed up at the airline and said, well, I hope you have a challenging career and we look forward to your contribution, but gee, if you can't fly the plane, you're going to have to go. Right? Nobody would expect that of the lawyer at the airline. But when we look at a firm, we often say, well, you're going to have to do business development and marketing and operations and research and development and accounts receivable and HR. Well, those are all very separate functions in most other businesses out there, and maybe we're stretching ourselves a little beyond what we were trained in when we expect lawyers to do that. Finally, like you, we're looking for better information about the profession, and we're putting together right now a proposal to develop a centre of expertise on the legal profession in Canada that will help us measure our progress against the kind of recommendations we have, and hopefully give us some insight into where the roadblocks are, and then we can help get them out of the way to lead to greater innovation within the profession.